Will Worsham joins us now for this week's Speaking Legal discussion, where he answers a viewer's legal question on air. First of all, Will, always good to see you.
Thanks, glad to be here.
Thanks for coming back.
Hey, you bet.
It'd be tough to do this question if you weren't.
Yes, it would.
We'll take a look at that question. My brother unexpectedly died from a heart attack, did not have a will. There was 160 acres of farmland that was passed down from my grandmother to my mother, then to my two brothers and I, which is currently in the grassland project. My brother's first wife and my nephew have now hired probate attorneys. My question is, since my nephew has not signed off on the land, is the land still part of the estate and in danger of being part of the probate procedures? I hope you understand this question.
There's a lot to that.
Maybe I need to take some notes here.
There's a cast of characters in there, and there are a lot of people, and they all want to know what to do.
Sure, so let's try to trace it through and make sure that I remember this and understand it. So we had a piece of land, and it was passed down, I'm assuming through some sort of probate transfer or something like that happened, to three brothers.
Yes.
That's what I got.
So the three brothers now each have an interest in the property. Typically, that's going to be tenants in common, which is a divisible interest. The entire property would not be tied up in the brother's probate estate, only his 1/3 interest, assuming that that's the way the property was split. So it kind of comes down to that. The property itself would not be tied up in probate, only the brother's piece would. So you got to figure out now who are the brothers' heirs. Now this is Kansas law, which is not Missouri law, and I'm not a Kansas lawyer, so I don't know what Kansas's non-probative transfer law is. So like in Missouri, intestate transfer law actually. Missouri's has a list of people who receive the contents of your estate if you haven't made any other arrangements, i.e. you didn't make a will. So Kansas's law is going to govern this here. The brothers may have a claim. The spouse may have a claim. The children of this deceased brother may have a claim. Which is the mother and the nephew. Yeah. Well, now see, that's where the wording gets a little funny, because there was a mother. I'm wondering if the three brothers' mother was still living in this scenario.
See, what this makes me think is, grandmother had it, gave it to mom, mom gave it to the brothers, the brother died, now that brother's wife and child... Ex-wife and child.
Yeah, the language in the question said first wife. So we could actually have a first wife, a child, a second wife, and the child, I don't know which wife is the mother of that child. That's going to make a difference, because in Missouri, if you have a deceased, you have a surviving spouse. If they have children, then they can get a larger share than if they don't have children, and it just gets really, really complicated.
Depends on a divorce decree and all of that kind of stuff.
Sure, that can make a difference, and then in some other scenarios, it would change things. But to kind of drill down to this question here, I think the point of confusion that this person may have that we could help them out with is the idea that the whole property is not in probate, just that brother's portion. So the two brothers that are living, their interest in the property is not going into probate. They can't lose that through the probate process. Now, they may want to hire a probate lawyer to get involved because they may have a claim on that third piece. The other situation is, and whoever ends up with that third piece, whether it be one person or multiple people, so now you get this property gets split up in more ways, you either have to agree on how that property is going to be managed, or you end up with a partition and sale, which you petition the court to order the property sold, and then the proceeds from that sale get split pro rata between whoever the heirs are and what their percentage ownership is once we're done with that.
Are things like water rights and stuff also going to play a part if it's running?
You know, water rights are kind of interesting, and I'm not sure if Kansas is there's two different ways, depending on whether you're a dry state or a wet state. The laws run differently, because the problem is either runoff or I don't get enough, depending on what your neighbors are doing. So that can be a problem, too.
I'm going to recommend hire an attorney.
Glad I don't have to figure this out. Well worth it.
If you have a legal question for Will, you can email him at wworsham at color10.com, and he'll answer your question on the show. And Will, thanks a lot for being here once again.
We'll see you next week.
All right, coming up, I had the chance to talk with global adventurer Lee Abamonte about some of his amazing journeys. You don't want to miss this. We'll be right back.